quite a bit of concern. I'm sure you probably also picked it up as media workers in senior levels of government, particularly in cabinet, about the leaking of information to newspapers. Particularly, I think we've had quite a series of cabinet memorandums that have appeared in newspapers and been quoted. If you remember the Kazanambo issue late last year and early this year of the documents about the repatriation of the skulls that he became very angry about. But just recently, I think in early August, the Works Minister, Tina, made a veiled threat in relation to the Namibia Airports Company report that was leaked to the media, saying there are confidential things in this world of ours. We want to arrest somebody. So you know, basically, there is a concern, I think, and we can talk about this a bit later if you've also picked this up from senior officials and ministers, that actually there appears to be some discussion, maybe informal at the moment, not officially in cabinet, about actually clamping down and seeking ways of punishing people who obtain leaked documents rather than opening up. I have to say that, you know, those of you who were journalists or around in the early 1990s might remember that the then Fisheries Minister, Helmut Angula, in 1994, actually called in the police when a leaked document on the sealing industry in Namibia, which has always been a controversial matter, appeared in the media. And he actually laid a charge of theft with the police and said he wanted to flush out the moles who were planted by the press, moles presumably in his ministry, and that the media freedom people in the press had to abide by the laws. So there always has been this antipathy to openness about information. It has to be said that I don't think the police really knew at that stage what to do about a theft charge. They were used to, you know, theft of physical property, and they found it hard to get their heads around the idea of theft of information or theft of a document. And nothing really followed on from that, fortunately. But it's a sign that the thinking really in government hasn't changed in nearly 20 years. And obviously that's to some extent because, you know, if you look at our cabinet, there's still quite a few people there who were around just after independence. So you know, the elder generation is still there, and they still have many of the same ideas about government information and secrecy. Basically, I mean, the Access to Information Bill was first suggested. First of all, we should say that it's not in the Constitution, because in 1989-1990, maybe access to information wasn't quite the buzz phrase that it's become in the last 20 years. And so it wasn't on the table when they considered the Bill of Rights for Namibia. But having said that, by the end of the 90s, we were talking about effective anti-corruption mechanisms. And there was a major conference in October 1998 that recommended an Anti-Corruption Act, and in tandem with that, a Freedom of Information Act. And actually, Cabinet that subsequently, in the following year, endorsed that report. So there was a commitment from 1999 to have an ATI bill in place in Namibia. But of course, as you know, it actually took them then another 8 years to actually act on the anti-corruption part of that commitment by actually creating the Anti-Corruption Act and then bringing the Anti-Corruption Commission into being in early 2006. So there was already a very slow process, and of course politically we could discuss why that was the case. But and then on freedom on access to information, there's been an even longer wait, despite some good statements and fine words at different times from senior figures in government. We're still waiting on that. Now, what we've seen this year is that, at least I know from talking to the chairperson of the Law Reform and Development Commission, Saki Shangala, and I think Misa also has had conversations with him and some of the commissioners, that they are now looking at access to information. They are now seized with the issue, and they want to come up with a consultation process and ultimately a draft bill for Namibia. So suddenly, in the last sort of 12 months or so, there seems to be an opening to move on this, and there is some political will at the top to get an ATI law into place. So we have a sort of window of opportunity at the moment, so one shouldn't be too negative, and it's a question of how we use that window of opportunity to influence the policy making and the law making process in the next year or so. Just to perhaps reiterate some of the points that were made already in the last discussion. Do we have access to information at the moment? I mean, can we get information anyway? Maybe we have our contacts and our sources, and we can obtain the information that we want. Well, we did an experiment back in 2010 as part of an Ask Your Government project, and we made 6 requests for information relevant to achieving the Millennium Development Goals in Namibia. And this was data relating to training midwives, procurement of drugs to reduce maternal mortality, volatility of development aid, government expenditure on environmental protection agencies, and the level of fossil fuel subsidies. So, all to some extent, issues that should be in the public domain, and none of them really having any kind of security implications or sensitivities that you would think would mean that the information could not be released. And also, general information that should be pretty much readily available to senior civil servants. So on average, it took 60 days to receive an answer. That's 2 whole months. And almost in every case, it was needed 3 or 4 repeat requests before any information was received. Though I'm sure you're familiar with this, but there was the reasons for delays there was a lot of bureaucratic bungling. So people transferred the requests to the wrong section or the wrong department, and this might also be a sign that people are fearful or unwilling in some way to release information, so they were kind of always passing the buck and passing it on to the next person to release the information. And then in some cases the wrong information was provided, and we had to go back and say, look, we actually were asking for this, and we put it all in writing, so it was all quite clear. So you can imagine if it takes researchers 60 days to get this kind of information, journalists who are working to deadlines of producing TV programs, radio programs, or articles for the next day or the next few days of the publications. You can't operate in that environment where you have to wait 2 whole months to get any kind of meaningful answer. So it's a clear indication that the system we have at the moment isn't working, and we aren't getting the information that we need in time. We've also at IPPR been involved in a growing movement worldwide, which is kind of linked to ATI, which is the open data movement, trying to get as much official data and stats available for researchers, for the public, for journalists. And what we find in Namibia is that Namibia does have a lot of information and official reports, and there are parts of government that do have things like the Labour Force Survey or the Household Income Expenditure Survey. A huge amount of information about Namibian society are available in some form, but in general it's all released in a haphazard and uncoordinated manner. And the Millennium Challenge Account actually did a report last year where they did say there was a need for much better coordination of stats. There was a shortage of trained human resources in terms of dealing with data in government. Accessibility was a problem, timeliness is a problem, and certainly the political interference is possible. And we saw this, I think, with the Labour Force Survey, where that report was actually delayed by a whole year. We saw that the draft report, and then a year later it came out, and the final report was no different. I even checked the same spelling mistakes were there. But the key issue there was in the intervening period between the unofficial release of the report and the official release, there was an election, of course. So it was clear that the information had been delayed, because it would have been embarrassing if it had come out in October 2009, just a month before the national election. So there is certainly evidence of political interference. How much info is government releasing? Well, this tells you part of the story. This was a screen grab of the Ministry of Trade and Information website, actually from the end of last year. I did check it yesterday, and now they do have an up and running website, so maybe this is a little bit unfair. But I think you probably have had this experience as well, that trying to use government's websites to get accurate, up-to-date information is more or less pointless in most respects. So even now, when you have a look at the MTI website, you'll find that it's mainly public relations. It's all about Hage Gangdop's birthday, actually. And if you want to find the latest trade figures, for example, who's Namibia's biggest trading partners, you can't find it on that website. So we've talked again a lot about e-governance over the last 10 years, but we've really made very little progress in terms of getting a coordinated system of government websites where information is released properly, continuously, and in a way that people can access it and understand it. So we've really been going nowhere in terms of our e-governance and the available reports on the internet. You will find reports on there, but they're quite hard to find. If you look at the National Planning Commission, you can find some reports on the census and recent surveys and things, but you know, so it's not obviously and easily available. Having said that, there are some positive signs that government might be changing or getting its act together in terms of statistics. We had the Stats Act that was passed in 2010. And the NSA has been set up. It's headed by John Stapler, and I think he does have a genuine commitment to making government data available. But what we haven't seen yet, and hopefully it might still come this year or early next year, is a proper NSA website, which acts as a web portal where all the key government data and information can be made available. But the positive side is that there is this global trend towards access to information and open data. So if we want to be part of that and be part of meeting international and regional standards increasingly, we need to be going in this direction, and that's one of the things we need to persuade government why they need to be acting more urgently on these issues. Unfortunately, the present situation is not a good one, really. As you know, the release of information is piecemeal. You have to struggle to get any official to release information, and often you're just referred always to the permanent secretary if you want to get any information, even fairly basic information. Now, Namibia still actually has a Protection of Information Act dated from 1982. And essentially, it's a mechanism of the apartheid state security system at the time. No, it has never been repealed in 22 years. Now, as far as I'm aware, and Lisa might be able to correct me, but that act has never been used actively to suppress information release or to victimize journalists or civil servants. But the very fact that it's still there, I think does have some kind of chilling effect on the way that information is released in Namibia. And again, of course, it's ironic that that's almost the same name of the bill that's now still being discussed in South Africa in terms of not accessing information but protecting information. Another, I think, reason why we find civil servants are generally so unwilling to cooperate with researchers or journalists or members of the public in releasing information is that officially they are barred from doing it. In Article 25 of the Public Service Act, it's a disciplinary offence to release information without the permission of the Permanent Secretary. So I'm presuming that this is one of the reasons why people are so nervous about releasing, civil servants are so nervous about releasing information. And we at IPPR called for that clause to be removed. At the very least, you have to say that information in the public interest should be released. Another issue which I think we need to discuss in more detail is what are the legitimate state security concerns in Namibia or in any country, and to what extent should they be allowed to zone off certain areas of information that can't be released. Now, the problem is that state security is often used incorrectly or unfairly to try and cut off information that might be politically embarrassing, but it's not actually anything to do with security concerns. But we do find in Namibia things like the Namibia Central Intelligence Service Act and the Defence Act are generally too strong in terms of trying to limit the release of information. Okay, I was also asked us to look at how a bill becomes law, and I think this is quite important because as journalists or also activists, we need to know how we can lobby and influence a government. And it's very good that the Prime Minister and then the Minister of Information will be involved in the agenda of the conference over the next couple of days, because I think we'll gauge, particularly from the Minister of Information, what the current feeling is in government, and whether they are actually veering towards protection of information rather than accessing information. But it's just interesting, those of you who maybe have covered Parliament, I mean, it's an interesting question to ask, and maybe somebody can, you have views on it, but who decides there should be a new bill, or where do our bills in Namibia originate? Any ideas on that? The bills that come up in Parliament, where are they coming from? Or where could they potentially come from? Anybody got any ideas? You can just shout out.
I guess. I was guessing that maybe it's how the people live, and maybe the way the people are maybe looking at something and maybe they are acting in a certain manner, then it is seen like that. That maybe we have to address a certain. Just guessing.
But which body is doing that? Which body is saying, okay, how do we, why do we? What I'm thinking about is, you know, your bill comes into Parliament, but where did the original idea of that bill come from?
Guessing that it most probably comes from the people if they want something, if they're unhappy about something, and if they're advocacy about a certain issue, then it becomes now something that a lot of people are talking about, and it can end up in the media. I mean, there's a just guessing, but I'm not sure.
So that would show that the public have some influence on the agenda in Parliament. But realistically, I think it would be interesting to analyse how many bills actually do come from some kind of pressure or civil society action. But certainly, it's a little bit of a mystery as to how bills do come to Parliament. But obviously, the main driver seems to be either the ministries or the cabinet itself, and maybe the ministries are responding to some grassroots perceptions of what is required. What we don't find in Namibia is that you don't really see very obviously bills coming out of civil society. So we have had in the past civil society groups suggesting bills, for example, Sister Namibia and the 50-50 bill a few years ago. It worked very well in terms of public education, but it didn't get very far in terms of influencing the parliamentary agenda in terms of passing laws. And then the other option would be private members' bills, that MPs in Parliament could actually bring their own bills and put them forward. But we've actually had very few examples over the years of any MPs bringing private members' bills. I think the only one I can remember is Costa Pretorius and some bill where he wanted to promote the use of Afrikaans. And it was shot down at the first hurdle before they even debated it. The SWAPO used its 2/3 majority to throw it out immediately. So it's not easy to get a private members' bill on the agenda, but also very few MPs have attempted to do it. So then bills come up and are put forward by the ministries and drafted in the Ministry of Justice. Then they go to the Cabinet Committee on Legislation, and then Cabinet for full approval. What's not systematic in this is how much consultation takes place on any bill. So some bills we know are put out for consultation, not usually generally that widely, but maybe to interest groups or groups who are perceived to be interested in the bill. As a draft bill, it's put out for some limited consultation. But other bills just appear in Parliament without any consultation at all, so there's no systematic process there. But obviously if there is a consultation process, and that's a real chance to influence the legislation, and we hope with an ATI bill that there will be serious and meaningful consultation, wide-ranging and also national, to discuss that. The Attorney General then certifies that the bill is consistent with the Constitution after the Cabinet has approved it, and then it's more or less ready to go to Parliament. A bill goes through three hearings in the National Council and the the National Assembly first, and then the National Council. Certainly in the second reading and the committee stage of the bill, that's when the bill is discussed in detail. First of all, its principles, and then its clauses. There is still an opportunity to lobby MPs and to express views about the bill. And in one or two cases in the past, that has ended up with the bill then being referred to a standing committee and public hearings being held. So it's certainly worth engaging. I know we have the view that maybe SWAPO is, as a two-thirds majority party, acts monolithically, and just if the instruction comes, it just passes the bill automatically. But I still think there is some experience that shows it's worthwhile trying to talk to MPs at that point. If there are misgivings about the bill or there are clauses people feel are missing, to try and influence the bill at that stage. It's much better if you can do that at the stage when it's in the National Assembly, because the National Council, as the upper chamber in Namibia, has much more limited powers and can only basically make suggestions about the bill. They can object to the principle of the bill as well, and they can send it back to the National Assembly. But at the end of the day, the National Assembly can still push it through without the changes that the National Council says. So the National Assembly is clearly the more powerful of the two houses. However, there have been cases where sometimes you're going to be able to pick up worrying bills in the National Council. One instance was the Communications Bill of 2009. If you remember, that was a so-called spy bill. And the National Council did organise public hearings on that. And about 30 civil society groups made quite impassioned pleas about that. And the National Council, to its credit, took some of them into account and issued a report to send back to the National Assembly. Unfortunately, what happened in that case was that the Minister of Information then just said, no, we ignore all these points that have been made, we ignore the National Council, and National Assembly just voted it back through again without any changes. That was obviously a very sensitive bill, and government had made a decision not to accept any changes. But there are examples where changes have been made. The Stats Bill Act of 2010, government did listen to points made by the Legal Assistance Centre and ourselves, and also Polytechnic and UNAM, about the way that the bill was restricting research, and did make some changes. And that was at the National Council level. And government accepted that those were good points, and put the changes through in the National Assembly. So one possibility also is to try and get the bill referred to a standing committee, where the standing committee often organises public hearings, sometimes just in Windhoek, but sometimes also nationwide as well. So that's another chance to get input into the legislation process. And then finally, the bill goes to the President for his signature and then published in Government Gazette and becomes law. And of course, by that point, we really lost the opportunity to influence the bill. All we can do, if one feels it's still not right, still not acceptable, is to push for an amendment. But because legislation takes so long to prepare in Namibia in general, it's much better to try and influence the pre-Parliament stage, when there's levels of consultation, or if the bill is not a consultation, to call for consultation, or to get into the National Assembly stage of the bill, and to influence the politicians at that stage. Now, I did mention earlier that this access to information issue is now before the Law Reform and Development Commission in Namibia. This is the arm of the Justice Ministry that develops legislation and also policy. And it consists of a full-time chairperson, the ombudsman, and then a number of people appointed by the president, but often recommended by different groups, such as the Law Society. Even UNAM is allowed to nominate a law lecturer. But essentially, mostly people with legal background. The LRDC in the past has played quite a crucial role. I don't know if anybody can remember any of the laws that the LRDC, or any of the issues that the LRDC has taken up in the past. Actually, they did a lot of work on gender issues in the 1990s and formulated the Combating of Rape Bill and the laws we have on domestic violence and things like that. So they have done good work in the past. As I say, they seem to be in quite an active stage at the moment, so we should seize this opportunity to influence and work with the LRDC. One of the key functions of the LRDC is to propose laws that will enhance human rights and fulfill Namibia's international obligations. Now, Karen will probably explain later that Namibia has a number of international obligations on ATI to do with the different international treaties and regional treaties and African Union statements that we've signed up to. So all of this can be used to influence the LRDC in this process. Now, it has to be said that the LRDC has often acted on legislation issues when a ministry is not obviously responsible. So, for example, in recent times they've been working on reforming electoral law, because that doesn't obviously fall under any ministry in Namibia. And so they've done actually quite a good job in terms of recommending draft laws that should come up. We don't know if cabinets ultimately will take them seriously, but we hope they will. It's been quite a serious process so far. However, the problem I think might come with the ATI issue is that the Ministry of Information may see itself as a sponsoring ministry and would try to limit the role of the LRDC. I mean, this is just a scenario that could take place, and I think the Ministry of Information may have quite a much more conservative or restrictive view of an ATI policy and law in Namibia than the LRDC would, simply because the LRDC represents outside government figures like just ordinary working lawyers. So we might see that dynamic develop. The other problem, of course, is that the LRDC has no guarantee that its proposals will be taken up. So it can present brilliant reports and draft bills to Cabinet, but Cabinet can still reject them. And we are a little bit concerned that some of the good suggestions on electoral law reform that the LRDC has come up with this year could still be thrown out at Cabinet stage or changed at Cabinet stage. So it's not guaranteed to produce the goods that we want, but at least there is a process in place that we can use. Okay, I did sort of indicate the ways that we can influence bills in Namibia. If there are initial consultations, it's best to get in at that stage before the law appears in Parliament, before the bill appears in Parliament. And one of the complaints of government is that sometimes they announce consultation processes and hardly any non-state actors take part. So we must make sure that that's not the case in this instance. That there has to be a strong lobby and hopefully united on most issues in relation to ATI. And then it looks like there will be a Law Reform Development Commission process. If it's like the electoral law, they will have some hearings and consultation meetings with different groups. So they, again, have to be taken advantage of by everybody interested in this issue, which includes the media, researchers, academics, but much broader civil society as well. One of the things you find in Namibia is that if you want to lobby ordinary MPs, I don't want to discourage it, but actually they have very little power to influence legislation, say the backbench MPs. So while that's important, it's also important to connect with the committees in Parliament.